And hi again, everyone. Appreciate you guys tuning in, of course. And I'm going to be talking about non-competes. Kristen teased this at the start of our presentation today, and it's finally here. So we are going to chat about non-competes and kind of what's the status and what's going on. And what's kind of interesting is, what are these things? Are they non-competition agreements, non-competes, hyphen, no hyphen? I didn't even include on there. You can also call them covenants not to compete. They're all the same thing. Basically, what it means is that it's a company or an employer prohibiting an employee from going out and competing with their business, whether that's starting their own new business or competing with a competitor, anything like that. So it's all of that. Those are different than like non-solicit agreements, and I'll talk about those a little later. So that's just the basic overview. And of course, there are some general terms that come along with most non-compete agreements. A lot of times it's a time period. How long do these non-competes last? A year, 18 months, 2 years? How widely spread are they? Is it for the entire world? Is it just for your state? Is it for your city? It used to be, hey, it's a 50-mile radius. Things have changed now with the internet, with global scope, and so they're now a lot broader, but certainly it's the geographic scope as well. And also, who exactly is that competitor? How do you define the competitor? And what does that look like to your business? So all of those things go into terms of what a non-compete agreement typically has. Now, why do we have non-competes, or why do people like them? Well, some people, if you're an employer, say, we got lots of pros for non-competes. We love them. We want to retain our great workers. We want to stop turnover. We want to protect our company information. So there's a lot of reasons that employers say, we don't want to spend all this time and invest so much in you, only to have you go out, quit, and go compete, steal all our good stuff. That's not okay. And we need some protections for that. Totally valid. Very many good reasons to do that. What about for employees? Are there any benefits for employees for non-competes? I think most employees would say no. But some say, yeah, you know what? If a company is going to want me to sign a non-compete, they're going to have to pay. I'm going to use that as a negotiating tool or bargaining tool to get paid more, because I know that once I leave, my options are limited. And so I better be getting a dang good deal while I'm here. Let's talk about the big one, what the Federal Trade Commission, or the FTC, did this year. Now, there was a proposed rule, but in April of this year, the rule was approved. So the final rule was approved, which bans non-competes for all workers. That's employees and that's independent contractors. And it was supposed to take effect in September of this year. And so I think the FTC got like 26,000 public comments. Lots of people had lots of opinions about this, but they went ahead and adopted this rule banning non-competes anyway. And one of kind of their reasons is, hey, we want to help individuals. We want to promote innovation. We want the world to have more competition, people not to be stuck, more mobility, more creativity. Do you know that the FTC estimates over 101 million workers are subject to non-competes? They said, imagine if those 101 million workers could go out there and do whatever they wanted, get creative, start their own businesses. So this is what the FTC was thinking when it went into its rulemaking process and ultimately adopted this rule. And they said, not only are we going to say no non-competes going forward, we're going to make this retroactive, actually. So retroactive for everyone except for certain senior executives making more than $151,164 a year and holding a policy-making position. You'll note that same number, I think, came up in Kristen's presentation, that is the kind of federal salary threshold now for overtime exemption. So they tied it into that. So this is what the FTC did. Oh, and they also said, not only are we going to ban non-competes, employers, you must affirmatively tell your employees that non-competes will not and cannot be legally enforced. So it was putting an extra step for employers. But hold your horses. Before September came around, what happened? Well, a Texas judge says, no go. FTC non-compete rule is unlawful, says the rule shall not take effect. Now, there are a number of different cases that were going on challenging this rule. Even in an earlier case, they said, hey, for these particular employers, we're going to say you can't enforce it. But this Texas case is the one that said, we are going to apply this for everyone, for all employers. And the reasoning is because the FTC exceeded its statutory authority. And then the judge found that the rule is arbitrary and capricious. And what's really interesting, and again, tying back to Kristen's presentation from earlier, is kind of the new laws. And now courts have, they no longer have to give the same level of deference to the FTC or other agencies making decisions. They have more power to make their own decisions. And so that's exactly what happened here when this judge says, nope, we aren't going to allow this non-compete ban to go forward. So where does it stand right now? So right now, the non-compete rule is not enforceable. So I should say the non-compete ban is not in effect nationwide. Now, the FTC can appeal. And I believe they have until a little later this month to do that. Who knows what's going to happen? If they do appeal, it's going to go up to the Fifth Circuit, which tends to be more business friendly. And there have been some other decisions in other jurisdictions with different rulings. And so potentially it could go up to the US Supreme Court. Who knows yet? So this is one we're going to wait and see, but it's very important to stay on top of, see what's going to happen. It could die and go nowhere, or geez, we could be looking at this again in the future. And so it's good to pay attention to what could be so you know how to protect yourself if it does come up. But what also this means is that we are left with kind of the status quo. So what was life like before this FTC non-compete ban? Well, life in Washington is that we had a non-compete law already. So here is our non-compete law. It generally says a time limit of 18 months is most appropriate. We, in fact, will presumptively say that anything longer than 18 months is not enforceable. You really have to have some clear and convincing evidence for the business reasons for goodwill or protecting your business of why it has to be longer than 18 months. So just note to selves in Washington, don't flirt with more than 18 months, stick to that. You also have to disclose this non-compete before someone is hired, or if they're a current employee, you need to be giving additional consideration to them. And that can be a number of things. Sometimes it's a raise, sometimes it's one set chunk of change in exchange for signing a non-compete, but it's got to be something more than just continued employment. There's also a salary threshold. So you can see my numbers here, and I think Kristen talked about that too. Here's the salary threshold for employees and independent contractors. And so that means if your employee is not making these amounts, or your independent contractor is not making this amount, then the non-compete isn't going to fly. So this is to protect, kind of the lower, I shouldn't even say lower wage workers, but workers earning wages less than these specific amounts, so they have more options for mobility. Now, I included this one in here because people do ask, well, what happens if I have to lay people off? Do the laid off employees still have to abide by this non-compete? Well, they do if you're willing to pay them for the non-compete period. So let's say you have a 12-month non-compete, you lay someone off, but you don't want them to go out there and get another job, then you need to be paying them their base salary during that non-compete period. So something to pay attention there too. Now, if you have a non-compete agreement that does not meet these requirements, what does that mean? It means the non-compete is void and unenforceable. So it's no good. Well, what happened this year? Well, this is my longest slide. So lots happened this year for the Washington non-compete laws. So you can see starting effective June 6th, the new laws went into place, clarifying, expanding our Washington non-compete law, essentially tightening up those restrictions and making it a little harder to have your non-competes out there and enforceable. So I've listed a bunch of things on here, of course, but the non-compete definition is now broader. So it doesn't include non-solicits, and I'll get to that in a sec, but in general, non-compete is broader. And basically now it includes any agreement that prohibits an employee's acceptance or transaction of business with a customer. So that is new. For those non-solicits, again, they aren't part of the non-compete law, but non-solicit agreements are now limited to current customers only. So a lot of people do their non-solicits and say, oh, it's former, prospective, anyone in this business space. No, current customers only. Also, clarifying that earlier notice is required. So I mentioned before how you have to have notice, but what you really need to do is it needs to be now before oral acceptance. So think about those times you're on the phone or your hiring manager's on the phone making that job offer. Oh, we want you to come work here. Isn't this so great? And the person on the phone says, oh, I'd love to accept. Not good if you have not told them about the non-compete already. So you need to move that non-compete discussion up much earlier in your process. So even before an oral acceptance, the person has had notice of the requirement for the non-compete as part of the job. This one, the non-party enforcement is new, and there's some question on what that means. But basically, it's before the parties to the contract get to enforce the agreement or say it's unenforceable, right? Well, this allowance of non-party enforcement could mean, is it a prospective employer of your leaving employee that gets to try and say, hey, we don't think this is a valid non-compete? So something to keep in mind that the scope of enforcement is now broader. There's also sale of business comes up, and there's an exception for that. So usually it's employees that have the non-competes, but when you're selling your business, let's say you're selling all the assets and someone's starting it, there are some different rules related to that. And the narrowed exception is basically you have to have the amount of business being sold has to be 1% or more of the business. So that's a little different than kind of what we're talking about for most employees, but I just wanted to flag that for you guys as well. And last one, this isn't on here, but I think it's worth noting. If you try to get around these Washington non-compete laws and say, oh, well, our agreement is governed by, Delaware law or some other state, no go. That is void. So if you're attempting to do that, that is forbidden. You are stuck. If you're entering into a contract here with your Washington employee, then you need to stick with the Washington law and the non-compete laws apply. All right, what can you do if you're like, oh, geez, this non-compete is getting narrower and who knows what's going to happen if they're going to be outright banned either someday in Washington or nationwide? You as a company still have options. You still have protections available to you. Remember those non-solicits I was just talking about? Use those. I think, that's a great way for you to think about how can we protect, either, solicitation of business or employees. So maybe you want to have your employees not being stolen by employees that are walking out the door. That's great for a non-solicit. There are a bunch of other agreements available as well, confidentiality agreements, trade secret protections, invention agreements. A lot of these times they're actually all part of one document, and that's okay. You can have either a non-compete in there or not, and you can have one other agreement with your employees that gives lots of other protection to your business information, your know-how, stopping poaching of employees, that type of thing. And those are not governed by the Washington non-compete law. And so it's really a nice opportunity to think, okay, what makes sense? Where do I see the world going with non-compete law, which, spoiler is things aren't looking so great for non-competes. Beef up some of your other protections to the extent it works for your business. And so you see, I put down here, really assess, like, what are we trying to do? Are we really trying to stop people from going out and getting other jobs? Or are we trying to protect certain parts of our business that we don't want getting out there? Are there other ways we can do that at this moment in time aren't subject to such strict scrutiny as non-competes? Okay, what do you do now? We've got all sorts of things happening, state, federal, lots of excitement with non-competes and other agreements this year. How do you take action? Here's how. First thing, you take a look at what agreements you do have, and you review them and say, am I in compliance? Or, geez, now that I just heard today about all these new things that are happening even in Washington, is my agreement compliant? Is it not? Do I have problems there? And then assess, can I enforce this, or do I need to do something new? Perhaps do I need a new agreement where I need to give new consideration and have my employees enter into that? Oh man, review those hiring processes. You don't want that rogue hiring manager out there making that job offer, getting the acceptance on the phone, and never got out the non-compete. You won't be able to do it if you didn't get it out before that oral acceptance. Obviously, keeping up to date on laws is so essential. I've talked about that. I hope that a lot of you guys are actually up to date on what I'm talking about today, because we do put out employment law alerts. And so, to the extent you guys aren't on our email list, make sure you're on it. We really don't spam you. We just try to give you some key updates. You're welcome to email me. We've got it on our website that you can subscribe as well, but it's a great way to keep up to date on all the key employment laws. And then if you're at the point where you want to actually enforce your non-compete agreement and you've got a departing employee, you're like, oh, what do I do now? And before you go off, firing off that letter saying you have violated your non-compete, or hiring that lawyer saying we are suing you, stop, take a minute, look at your non-compete and assess. Is it still enforceable, knowing what the laws are like today? Is this something we want to put our energy behind? Do we have other options? So just make sure you've got all the information before pursuing that.